This is a presentation about representing an applicant before the European Court of Human Rights. The objective is to familiarize you with the procedure before the European Court of Human Rights. So I don't know that you'll leave today with any better understanding of the substance of the case law of the European Court of Human Rights when it comes to specific violations, sort of what amounts to a violation of Article 8 or Article 3 of the Convention. What you will leave with, I hope, is a better understanding of how procedurally to take a case before the European Court of Human Rights. If you wanted to look at the case law of the European Court of Human Rights, there is HUDOC, which is the system, the online system for searching the court's case law. It's gotten better in the past couple of years with some funding from some of the governments. It now has a much more effective interface for searching. I think it takes a little while to get used to how to search with this. In particular, if you look over here, let's say that you only want Article 8 cases. You have to learn how to use this system over here for ticking which article you want. But you can do it, and it will give you the cases that you want. So for example, Marcello is currently working on cases, a potential case against Italy about children, Roma child, not being returned to the family. We might want to look at all of the Italian cases under Article 8 involving children. What we could do is we could enter Italy in case title, we could enter children in text, and we could take Article 8 and see what we get. But we'd want to do that in two languages. We'd want to write Italy in English and child and tick Article 8. We might also want to write Italie in French and enfant in French to get all the French language cases that come up as well. The two official languages of the Council of Europe and therefore the court are French and English. And unfortunately, not all of the case law is available in both languages. And particularly if you look at admissibility or inadmissibility decisions, they often haven't been translated. So, and particularly for Italy, for example, French is often the language that's used. It depends on the country. I'm happy though if you want to intervene and ask a question. Just if it's something that really is related to this, then go for it.
I didn't understand this. In this database, those are all cases that are finished.
They're not necessarily interested. It's a very good question you've asked. They're not necessarily cases that have been finished. I'm glad you've asked that. Cases that are finished that have ended in a judgment are here, and the judgments are here. Cases that have ended in a decision, an admissibility or an inadmissibility decision are there, but some cases, we'll discuss this in a moment, that have decisions aren't finished yet. So they're in there. And perhaps most importantly, you see, well you can't see probably, but there's something called communicated cases. About 90% of the cases that are lodged with the European Court of Human Rights are more or less thrown in the bin as soon as someone looks at them. So they're never communicated, which means that they're never sent to the government of the country concerned to answer them. The court looks at it and says, no, it's inadmissible, and gets rid of the case. But a good 10% of the cases are communicated, which means that you can think of it, it's not that they're admissible, but the court has concluded that there is a case to answer, and so sends the government by communication the information about the case. And those are communicated cases, and what happens with those is that the court writes its own statement of facts. And the statement of facts is what goes on the website, so you do get some ongoing cases there. So basically, from our perspective, there are two main stages in theory in the life of an application in the European Court of Human Rights. The first is admissibility. Is the application admissible? Does it meet certain criteria to be considered by the court? The second stage is the merits. So if the application is admissible, is there a violation of the European Convention on Human Rights? In practice, though, most of our cases here at the ERRC will have those two things considered together formally, admissibility and the merits. But those are the two stages in theory. Now the way and just to give you a point of vocabulary, you cannot use the words decision and judgment interchangeably in the European Court of Human Rights. A decision deals with the admissibility of the case. So if someone says to you, look at this decision of the European Court of Human Rights, it's only a decision on admissibility. A judgment deals with the merits, or deals with both admissibility and the merits. So those are two different words. So we now have this system of 4 possible judicial formations for disposing of applications. So these are the ways that the judges can get together to deal with an application. The first one, in the upper left, is the most common. Under Article 27 of the Convention, there are 47 judges at the European Court of Human Rights, and the most common way of getting rid of an application, or dealing with an application, is for one of those 47 judges to look at it and declare it inadmissible. So a judge who is not the judge from the country against which the case has been lodged looks at the application and declares it inadmissible or strikes it out from the list. For example, they decide that you haven't gone to the national courts first. This is a very frustrating experience for a lot of people, because that single judge does not write you a long letter saying, this is why I've decided this. You get a form letter from the court saying, the single judge, pursuant to Article 27 of the Convention, has decided that your application is inadmissible. No explanation. And under the Convention, there is no recourse against this. There is no appeal. There is nothing that you can do. And so this is actually the response that most people will get. So you can see why a lot of people get very frustrated with the court.
And this is where everything ends. At this stage,
Everything ends at this stage. There's nothing else that you can do if you've been put into the upper left-hand corner. So that's the way most cases are dealt with, and it's very frustrating for people indeed. Your case might make its way to the upper right-hand corner, a committee of 3 judges. So let's say, for example, the single judge says, I'm not so sure about this, whether this should be inadmissible. But they can, a committee of 3 judges can be convened, and they unanimously can declare the application inadmissible or strike it out. They can also declare the application admissible and deliver a judgment on the merits of the case. Just 3 judges can deliver a full judgment on the case, but only if the underlying question is the subject of well-established case law. So you have large numbers of repetitive cases against certain jurisdictions. To give an example, Italy has a large number of cases about a right to a fair trial because of undue length of proceedings. So you might have that. I've never been involved in a case, I should say, that was decided by the committee in that way.
So, sorry, case law in a particular country or case law on a particular issue?
That's a good question. The language that's up there is all that the convention says. The underlying question is the subject of well-established case law. So it doesn't have to be against the same country. Let's say, for example, that the case law is very clear that in certain kinds of civil cases, a case that's lasted a certain period of time has violated Article 6 of the Convention. The courts have violated Article 6 of the Convention. Even if it's not Italy, the case law is most established against Italy. But even if it's now France, they can say, well, this is well established in our case law. So I don't see why they couldn't use that procedure in a case against another state. They might be less tempted to do so, because they think that it's not as big a problem there. Chambers of 7 judges are the ones who can take decisions and judgments if none has been taken by the single judge of the committee. So they're the ones, most of the cases, most of the judgments that you'll come across have been decided by a chamber. The ones that really are the new case law of the court. So 7 judges are deciding these cases. They can deal with admissibility, they can deal with a judgment on the merits.
So for example, our DH was...
DH wasn't, DH in the first instance was dealt with by a chamber of 7 judges. And Orshush, which I'll come back to in a second actually, because it's more interesting I think in relation to this, Orshush was dealt with by a chamber of 7 judges. And in both of those cases, the chamber has decided that there was no violation of the European Convention on Human Rights, resulting from the segregation. So how did we get to the Grand Chamber, is the question. There are 2 ways of getting to a Grand Chamber of 17 judges. One is that the chamber relinquishes the cases to the Grand Chamber. That is to say that the chamber is seized of the case and says, this is very important, or very hard, or something, there's a standard that they apply for this. And so they say, we are going to relinquish our jurisdiction in favor of the Grand Chamber. So the chamber doesn't actually make any decision except the decision to relinquish. That isn't what happened in Orshush and DH. What happened in Orshush and DH was that the chamber delivered a judgment, and we asked for the case to be referred to the Grand Chamber. Now, some people, particularly in the British press, call this an appeal.
Yeah.
It's not an appeal. The language here is referral. It gets referred to the Grand Chamber. But in effect, the Grand Chamber can reverse the chamber, which is what happened in these school segregation cases. So those are the 2 words to keep in mind as well, to be careful about. Relinquish is when the chamber has said, okay, we're not going to deal with this, we're sending it straight to the Grand Chamber. Referral is when the case has already been decided by the chamber, and it gets referred to the Grand Chamber.
Can you do the same with the committee of 3 judges to refer
No.
to chamber?
No, you cannot. The chamber only gets referrals from, the Grand Chamber only gets referrals from the chamber, and importantly, it's not automatic. That's why it's definitely not an appeal. What happens is so let's say, we lose the Orshush case, we then write to the court and we say we are requesting that this case be referred to the Grand Chamber, and a committee of judges, well, not a committee in the sense of the upper right-hand corner there, but a panel of judges will then decide whether that case is appropriate to be referred to the Grand Chamber. And they're not required to accept any particular cases at all. And people in the legal team will know that we occasionally hear about cases being referred or not referred. For example, we were recently involved in a case called Winterstein versus France. We were the third-party intervener in that case. The case was successful. The argument that there was a violation found in very much in the terms that we would have wanted. We were waiting to see if the French government would request for it to be referred. They didn't. The Vona case, which I think you also know about, Mr. Vona lost his case. We intervened, suggesting that he should not win his case. Mr. Vona asked for his case to be referred to the Grand Chamber, and the panel decided not to refer the case to the Grand Chamber, so that judgment is also final. In the Orshush case, we lost the case 7-0. All the judges found against us in the chamber, right? And we asked for the case to be referred to the Grand Chamber. And the case was referred to the Grand Chamber. And in the Grand Chamber, we won 9 votes to 8. So actually, the majority, dare I say the vast majority of judges in Strasbourg who looked at the case found that there was no violation. And a minority found that there was a violation, but the right minority. So there we are.
And that is still all about decision, not about...
No, these are judgments. These are judgments on the merits. These are not, this is not, sorry, to make that clear.
Yeah.
Now, the chamber and the Grand Chamber can decide that a case is admissible or inadmissible. But in the Orshush case, the DH case, they were dealing with the merits of our complaint. They also decided that they were admissible at the same time. But the admissibility issues, there were no admissibility issues really in question in these cases. But this is what a case typically looks like in my experience working with NGOs. Before Rule 47 came in, and we'll talk about Rule 47 in a moment. So the first thing that I tended to do was send a letter of introduction to the court. So write a letter to the court about 2 pages long, saying, we intend to introduce an application. This is a basic overview of the facts of our case. These are the articles that claim we're going to be violated. We would then get a letter back from the court saying, thank you for your letter of introduction, or maybe not thank you, but if you've received your letter of introduction, here's the application number for your case. You have 8 weeks from the date of this letter to send us the full application. We would then get our skates on and send a full application to the court within 8 weeks. The court would then communicate the application to the respondent government. Now, 90% of the cases that are sent to the European Court of Human Rights end before that purple arrow happens. Because actually the court doesn't communicate them to the respondent government. It sends it to a single judge, and a single judge declares it inadmissible. But fortunately for the ERRC and the AIRE Centre and other NGOs that are specialized in this area, the majority of our cases don't get chucked in the bin immediately. What happens is a procedure that isn't actually foreseen in anything that we've discussed so far, where the court communicates the case to the respondent government. This isn't foreseen by the convention as a specific stage. It doesn't mean that your application is admissible. What it means is that there is a case to answer. The court wants to hear from the government, and will ask the government some questions. And at that point, in my experience, the applicant applies for legal aid from the Council of Europe, and hopefully gets the handsome sum of 850 euros. The applicant's representatives may also notify other NGOs that the case has been communicated, because a window has opened for other NGOs and other people to come in and say, we would like to intervene in this case as a third party. And so we may contact other people and say, just to let you know, this case was communicated, are you interested in intervening? Because not everyone is checking the court's website to see that these cases have been communicated. We then have the government submitting observations on our application. So the government writes back and says, no, 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 none of that happened, and even if it did happen, it's not a violation of the convention. We then submit observations on the government's observations and a claim for just satisfaction. So we write back saying, that at paragraph 2, the government says this, that's not true, this is what's true. And you go through bit by bit. And hopefully each of these documents is a little bit shorter than the others. If they're getting longer and longer, then usually there's a problem.
The claim doesn't go straight from the beginning?
No, the just satisfaction claim goes with the ops on ops, the observations on observations. So actually, all you need to do in the application is say that you're going to claim just satisfaction. But you don't need to make your claim then. The court will send you a practice direction on how to claim just satisfaction. And but when we say just satisfaction, money, damages. Pecuniary damages and non-pecuniary damages, referred to in most other European languages as moral damages and monetary damages.
The letter of introduction to the court has to be done within 6 months?
Yeah, well, this is the thing. This is pre-Rule 47.
But it's not valid anymore.
It says it's not valid anymore. So the reason why we were doing this was because the letter of introduction stopped the 6 months. But as we'll talk about in a few moments, there's no usefulness to it anymore, because the letter of introduction doesn't stop time anymore. Then the court delivers a decision on admissibility and a judgment on the merits together. That's in a typical case. No separate admissibility decision and judgment. They're done together. And then what happens? Applicant follows up, execution with government, and if necessary, the committee administers. Third-party interventions. Under Rule 44 of the Rules of Court, organizations and individuals have 12 weeks to write to the court to ask for permission to intervene in a case. Basically, a third-party intervention is where you think you have something to add to the case, even though you're not a party to the case. So, for example, in Winterstein versus France, that was a case about travelers in France being evicted from the sites, the halting sites, where they put their caravans and live. They were being evicted from those sites because those areas are not zoned for habitation. This is of huge importance to Roma and to the ERRC's work. So in 2009, our predecessors intervened in the case and did put a very good intervention in, and the case was successful. We weren't parties to the case, but we helped the court reach a good judgment in the case. Third-party interventions. Under Rule 44 of the Rules of Court, organizations and individuals have 12 weeks to write to the court to ask for permission to intervene in a case. Basically, a third-party intervention is where you think you have something to add to the case, even though you're not a party to the case. So, for example, in Winterstein versus France, that was a case about travelers in France being evicted from the sites, the halting sites, where they put their caravans and live. They were being evicted from those sites because those areas are not zoned for habitation. This is of huge importance to Roma and to the ERRC's work. So in 2009, our predecessors intervened in the case and did put a very good intervention in, and the case was successful. We weren't parties to the case, but we helped the court reach a good judgment in the case. So I've been hinting at new Rule 47. From the 1st of January 2014, the court introduced a new rule which deals with the contents of an application. So an application must be made on the form provided by the registry. You cannot send in your own application just on some piece of A4 paper. You have to use the form, which we'll look at briefly in a moment. And it needs to contain all of this information. Now, not all of this is different from the past. And in some senses, the court is asking now for less information. The court is no longer asking you to say what your client's occupation is, which is good because I've had the vast majority of my clients in the past have not had occupations. So it was a bit of a ridiculous thing to ask. But you need to give all of this information about your client. You need to give the name of the contracting party, a concise and legible statement of facts. So if it's scribbles that are not understandable, the thing can be tossed in the bin. And a concise and legible statement confirming the applicant's compliance with the admissibility criteria and laid down in Article 35(1) of the Convention. All of the information referred to above should be sufficient to enable the court to determine the nature and scope of the application without recourse to any other document. That's what a complete application consists of. The whole thing should be clear from what's in the form. The applicant may, however, supplement the information by appending to the application form further details on the facts, alleged violations, and relevant arguments. Such information shall not exceed 20 pages. So what we did in the P case was we submitted 20 pages of argument from there. The application form shall be signed by the applicant or the applicant's representative and be accompanied by copies of the documents relating to the decisions, copies of documents and decisions showing that the applicant has complied with exhaustion of domestic remedies, copies of documents relating to any other procedure of international investigation or settlement, and where represented the power of attorney, although now the court has incorporated the power of attorney into the form, and that's where they're expecting to see it signed. Documents submitted in support of the application shall be listed and ordered by date, numbered consecutively, and be identified clearly. Now, I've not made the application form big enough for you to see here, but this just gives you a sense of what the application form looks like. And it is better in certain ways. You can type into it now. So you can type directly into the form, and you see on these pages they're asking for all of the details. And just to give you something here, it says down here, signature of applicant. And that's where one of our problems is. Because the signature of the applicant is something that we're having a hard time securing in some of our cases. It's easy enough for us to get a form of authority signed maybe at an early stage. Now what we have to do at the early stage is print out that page.
But does that mean, sorry, if you have a power of attorney to act on behalf of applicant?
They also want well,
You know, because you are basically the applicant if you have power of attorney. Can it be like interpreted in that way?
I guess it could be, because if you look at this, it says the application form shall be signed by the applicant or the applicant's representative, and shall be accompanied by, where represented, the original power of attorney or form of authority signed by the applicant. So I suppose it depends how you interpret this, and it could work. But I guess we'll wait and see from the court. Now we have this with our case. We submitted a form of authority signed by our client, but we couldn't get her signature on the form. We'll see if it works. Now the court wrote to us and said we're expecting to see both, but they're not getting both because we weren't able to do it. Well, there's a separate place for us to sign. That's the thing. The form has two signature boxes. The form has a signature box for if you're being represented. That's the box that you see on the lower, on the second page on the lower left. And then at the end of the application, there's a second signature box, which is either for the applicant to sign or for the applicant's representative to sign. So in our case, ideally, we have our client sign there, and we have Desi sign at the end. If you're making your own application, that's blank, and you sign at the end. So yeah, no, the court's been quite clever about this. So we'll see what happens. So, but some of the questions that you've asked are not made very clear by the rule. This is the rest of the application form, statement of facts, statement of violations, and a brief statement about the exhaustion of domestic remedies. And I've already mentioned two issues. One is the form of authority, and the second is insufficient space on the form. Request for anonymity. There is a Rule 47, Paragraph 5 of the Rules of Court. Says applicants who do not wish their identity to be disclosed to the public shall so indicate and shall submit a statement of reasons justifying such a departure from the normal rules of public access. So at the earliest possible stage, you have to ask for anonymity if you want your case to be anonymous. So AA versus UK instead of the guy's real name. I've given you the contents of the practice direction on the right side of the screen. I won't go through that in detail, but if you're ever involved in requesting anonymity, which we did not do in the present case, that we're talking about, the Italian case, that's what you should have a look at. Our Rule 39 measure is a measure by which the European Court can require a party to do something or require a party to not do something. In the vast majority of cases, Rule 39 measures are used by the court to stop governments from deporting people. That's what happens. Not in our cases, of course, because we don't have very many ECHR cases that involve removals of people. And even M versus France, which I mentioned to you, she's not actually at risk of being removed from France in a concrete sense. No one's coming after her. There's just an order for her to leave France that can be executed at any time. So it's usually used in immigration matters. It's been used in other contexts as well. It was used in one case to stop the British authorities from destroying embryos of a woman who wanted those embryos to be turned into people. Because she and her partner had created these embryos with the help of the National Health Service, and he broke up with her, and he no longer gave his consent, and she had an Article 8 case about turning the embryos into human beings. And it was used in one case to require the Russian authorities to provide HIV treatment to someone who is in prison. So it can be used in other circumstances. There's a web page on this on the court's website, so that's the thing to consult when doing this kind of request. There are three ways in which the court can dispose of a Rule 39 request. One is the way that they dealt with it in our case, P, in which the court said this falls outside the scope of Rule 39, and they throw it in the bin without even showing it to a judge. The second way they can do it is they can say, this decision falls within the scope of Rule 39, we're going to show it to a judge. Then the judge looks at it and says, I'm not granting this Rule 39 request. Throws it in the bin. And the third way is that it goes to the judge, and the judge grants the Rule 39 request. And there are statistics about how many get accepted and how many get refused. The vast majority of Rule 39 requests are refused, but not as vast a majority as you might think. There are some judgments in which the court has more or less said what the criteria are for granting a Rule 39 request. And they're not listed up here, and I can give them to you separately. But in some of the immigration cases, the court has said why it grants Rule 39s.
And there was no reasoning why in this PK it was denied?
All they said is that it fell outside the scope. I mean, if you ask us why, because they seem to think that it was basically, Rule 39 is reserved for Article 3 questions, inhuman and degrading treatment or torture. Or Article 2 questions, death. Ours is, now, there are some Rule 39s that deal with Article 8. Ms. Evans and the embryos, that was not an Article 3 matter, that was an Article 8 matter. but it was considered to be such a strong, important Article 8 point that the Rule 39 should be granted. Now, we argued our case under Article 3, that evicting our clients in this way was inhuman and degrading. The court obviously disagrees with that, says it's only an Article 8 matter, and it wasn't an Article 8 matter like Ms. Evans' Article 8 matter. It deserves a Rule 39.
So just one question. If you apply for this Rule 39, let's say, and they grant you, do you need to follow up with the whole case?
Oh, yes.
Or not?
Oh, yes.
Yes.
And what the court, not only do you need to follow up, but you need to follow up quickly. Normally, the court will set you a deadline for the full application, and it is within a matter of 3 or 4 weeks.
So, but in this case and in Jordanova, you're a victim of a potential future violation, or no, there was a violation because they didn't take the
In Jordanova, it was a
proportionality.
In Jordanova, it was a potential violation because the violation is the eviction. So so this is the difference between, we'll talk about victim status in a moment, but you can be a victim of a human rights violation that has already happened to you, or you can be the potential victim of a human rights violation because something is going to happen to you. The court will consider both of those cases. And Jordanova was a potential case. AA, the Nigerian guy, potential violation. P,
But
violation.
what was the difference in practice between Jordanova and, because for me it sounds,
In Jordanova, they were never evicted.
I understand, but the threat was the same.
How come?
But in P, it
But
was
in P,
even-
it actually happened.
So we felt, okay.
In P, they were chucked out. Their homes were bulldozed. So the violation actually happened.
But after we submitted the...
No. We submitted the Rule 39 on the Thursday night. On Friday, they rejected it. On Monday, they were evicted. And then in February, we lodged the full application. So we're complaining about a violation.
So even if it's rejected, this Rule 39, you can still apply?
Oh yes, absolutely. This is Article 35 of the Convention, which sets out the admissibility criteria. To summarize them briefly, an application cannot be anonymous. It can be anonymized, but it cannot be anonymous. That means that you have to tell the court who you are. That's very important. The second thing is that it cannot be substantially the same as a matter that has already been examined by the court, or that has already been submitted to another procedure of international investigation or settlement. This is a bit what Jojo was getting at before. What happens if I'm unhappy with what's happened to my case, and I say, you know what, I bet if I go to another single judge, they'll see this differently. Now, if you don't do that right away, in theory, your application is inadmissible. Now, of course, the court might not notice that it's the same application, because the court's receiving a lot of applications. On the new application form, you are required to declare whether you've ever made an application to the court before. So if you lie on that bit of the form, they might declare your application inadmissible, or not inadmissible, but otherwise invalid for that reason. It also cannot be, but someone asked me about this in the past, what happens if my case is very similar to someone else's case that's been decided? That's okay, because they're different cases. So these repetitive cases, for example, the court does consider those. Other cases that have been submitted to another international procedure, or procedure of international investigation and settlement, that's a real issue. And Andrea brought it up a couple of minutes ago. We have this issue about, what if I want to go to the CEDAW committee, for example, in addition to going to the European Court of Human Rights. You have to look at the procedures of those committees to know how they will handle the fact that you've been to Strasbourg. But if you've lodged a complaint with CEDAW, and then you send it to Strasbourg, it will be inadmissible, because it's being considered by CEDAW, or has been considered by CEDAW. So there's a kind of procedural conflict rule on there. Applications are inadmissible if they are incompatible with the provisions of the Convention. Oh, sorry, I missed the most important one at the very top. The court may only deal with the matter after all domestic remedies have been exhausted, and this is the one I'm going to go into in a couple of minutes in more detail. So you have to exhaust domestic remedies. You have to go through the national procedures that exist for dealing with your complaint, and you have to lodge your application within the court within 6 months of the final domestic decision. And there is a protocol to the convention that will come into force at some time soon that will reduce that to 4 months. But now it's 6 months from the date of the final decision. So those are the two most important, and we'll get back to those in a moment. Then there are some that I'm not going to go into too much detail with you about. The application should not be incompatible with the provisions of the convention. The only examples that really come to mind for that are when people who have denied the Holocaust happened and are punished for that attempt to go to the European court claiming that they are victims of a violation of their freedom of expression. The court has found those applications to be incompatible with the convention. Or the application is not manifestly ill-founded. Now that's a very interesting phrase. Basically what it means is that the application actually raises some issue under the convention. A lot of applications get dismissed as being manifestly ill-founded, sometimes in inappropriate circumstances, people would say. That at least it should have gotten a proper consideration on the merits, but that is a category. A particularly frustrating category, you can imagine, for a lot of people. But there you are. That allows the court to dismiss a large number of applications as being inadmissible, even if they meet the other technical criteria. And then there's this one, which was introduced relatively recently. The applicant has not suffered a significant disadvantage, which I'll talk to you a little bit about. I don't think that would affect any of our cases. All of our applicants, I think we could say, have suffered a significant disadvantage. Segregation in schools, losing their homes, that sort of thing. I'm not going to spend ages and ages on admissibility because the court has published a 92-page practical guide to admissibility, which goes in detail in the case law, and it really is very, very good. So you can read that on your own if you have any question about admissibility. Now, it was last updated in 2011, so you might want to look at more case law since then to see how things have evolved. But it is very much a comprehensive guide to admissibility issues, and it's available in 25 languages. So really, it's excellent. So that said, this is a basic overview. In terms of exhaustion, what are the basic principles of exhaustion? The purpose of the exhaustion rule is to afford the national authorities the opportunity to make right a violation of the convention. Right? So states shouldn't be punished at European level until they've had a chance to put things right domestically. This is, I love this quotation from the Admissibility Guide. The exhaustion rule may be described as one that is golden rather than cast in stone. So a little poetry there from the court, which basically means that it's a very important rule, but it might vary in different cases. So in some cases, you may not be required to exhaust. You may not be required to exhaust particular remedies. There's some flexibility. You do not need to exhaust remedies that are not practical and effective. That's a phrase from the court's case law. Practical and effective. The opposite of practical and effective, theoretical and illusory. So if you want to say that you didn't have to exhaust a remedy, you should say that the remedy was theoretical or illusory, and explain why that is. You must comply with domestic rules and time limits. So let's say, for example, that you've taken your case to the first instance court and you've lost, and you've appealed to the Court of Appeal and you've lost, and then you wait 6 months and apply to the Constitutional Court of the Supreme Court, but there's a 2-month time limit, and they reject you, and you say, great, I've exhausted. No, you haven't, because you violated the procedural rules of the domestic courts. If there are several remedies available, you only need to exhaust one set of remedies. So let's say, for example, that we have an eviction. There might be 10 different ways under domestic law that we can challenge that through the administrative courts, through the civil courts, through other procedures. You only need to exhaust one set of remedies, but the set of remedies that you've exhausted must be effective. And you must raise the complaint in substance before the domestic courts. So the best thing to do, and we do this a lot when we work with domestic lawyers, is we tell them to cite the convention and cite the convention case law. Because if you haven't raised an argument before the domestic courts, you violated that first principle.
But
You've not afforded, yeah.
But there is actually a case law found because I always have this dilemma whether you need to,
No, it's in substance. You're right. So you don't have to mention the convention at all. You don't have to mention articles of the convention at all, as long as you've raised the complaints in substance. But if you want to be careful about the matter, you raise it in the text. The burden of proof on exhaustion. This is taken from a case called Salmuni versus France. But basically, it sets out how the burden of proof works on who has to prove about exhaustion of domestic remedies. Now, I mentioned to you that the vast majority of cases get chucked out by the court before being shown to the government, right? Those 90% or so of cases that are ruled inadmissible by a single judge. They're not being communicated to the respondent government, which means the government never has to say anything about exhaustion. So obviously the burden is on us, in the first instance, to show a case that there has been exhaustion of domestic remedies. The way the court says it here is Article 35 provides for a distribution of the burden of proof. It is incumbent on the government claiming non-exhaustion to satisfy the court that the remedy was an effective one, available in theory and in practice at the relevant time. That is to say that it was accessible and capable of providing redress. Once the government satisfies that burden, the burden is back on us. So I think it's actually there are three parts to this. We have the initial obligation to show the court that we've exhausted, because the court's only going to look at our application to start with. If the court communicates the case to the government then has to claim non-exhaustion of domestic remedies and has to show that there was a remedy capable of providing redress. If the government is able to do that, we then have the burden of showing that the remedies they have cited are not, in fact, practical and effective. So that's the way this works. I just thought I'd give you an example here, and I apologize for the citation in French, but I can give you an explanation of what it is. The case was Carusiotis versus Portugal. Ms. Carusiotis is a German citizen. She has a child with a Portuguese citizen, and the Portuguese citizen leaves Germany with the child and goes to Portugal. But you're not supposed to do that. You're not supposed to take children outside of their jurisdiction of habitual residence without the permission of everyone who has rights of custody in respect of that child. And he did not have the mother's permission. So the mother went to Portugal and took two sets of proceedings. One, to get custody over the child, and the second, to have the child returned to Germany. And those proceedings lasted ages. And by the time she made her application to the court, neither of them had wound up, and one of them wound up shortly after she lodged her application. And the Portuguese government said, wait, you haven't exhausted domestic remedies. The case is still ongoing. How can you complain about a case that's still ongoing? And the court said, yes, but her complaint is that the violation results from the length of proceedings in the case. And the court said, these things are so bound up with each other that they can't be pulled apart. The violation resulting from the excessive length of proceedings. And so there was no, in this case she was excused, if you like, from exhaustive domestic remedies, because her complaint was about the nature of the remedies themselves. In expulsion cases, if a person is claiming that his or her expulsion from the territory of a country will result in inhuman and degrading treatment or torture in violation of Article 3, the European Court has said that an effective remedy must have automatic suspensive effect. That has two consequences. One is that states can violate the convention by not providing asylum seekers with a remedy with automatic suspensive effect. In the Medine case, people would show up at the airport in France and they would say, I wish to claim asylum. And the border guard would say, very well, you have asked for permission to enter France for the purposes of claiming asylum. I will consider whether to grant you permission to enter France for the purposes of claiming asylum. In the meantime, you are not in France. You are in the arrivals area of Charles de Gaulle Airport, not France. And then what the person would come back in many cases and would say is, I am refusing you permission to enter France for the purposes of claiming asylum, because I think your claim is bogus, basically. And the person would, and then they would say, we're arranging a flight for you back to your country of origin, or wherever you can be sent. And the authorities would then come for that person and force them onto a flight. There was a possibility of appealing the decision to refuse them permission to enter France to a judge in Paris or wherever. But making that appeal did not suspend your removal. So you could be put back on a plane while the judge in Paris considers your case. No effective remedy. So that's the one consequence. But the other consequence is that if you're someone in this position claiming that your expulsion will result in Article 3 ill treatment, and you don't have access to a remedy anymore with automatic suspensive effect, you don't have to exhaust that remedy. And you can go straight to Strasbourg. About a year ago, I was helping to train an organization in Paris that looks after LGBT asylum seekers, talking about how they can take cases to the European Court. In France, you claim, assuming now you're in France, forgetting this airport scenario, you're in France and you're claiming asylum and you're refused asylum properly by the organization that deals with that, the French state body. You then make an appeal to what's called the French National Asylum Court. That is suspensive. So while that case is being heard, they cannot remove you from France. You then lose your case. You can then launch an appeal to the Council of State in France. But that appeal itself is not suspensive. You can ask the Council of State to suspend your removal while they consider the case, but often they take several months just to consider the request for suspension. My advice to the people at that NGO was they could go straight to Strasbourg, because they've exhausted the effective remedies available. Now, I think the European Court would still expect you to have lodged the appeal with the Council of State and to have requested suspension. But if you've done that, I think the European Court will should accept your application as being admissible, because you've exhausted all of the effective remedies available to you. Exhaustion in P and others. I've given you here some text from the application that we put in. So in P and others, the eviction case, we exhausted no domestic remedies. We never had a bit of paper to challenge, because the only thing that we had was these people in plain clothes coming to the settlement and saying, you're going to be evicted next week. So this is what we said to the European Court about this. The applicants note that the court's case law requires that the exhaustion of domestic remedies be considered in the light of the applicant's particularly vulnerable status as a Romani woman, and in the light of the refusal of the authorities, of the municipal authorities to respect basic principles of Italian administrative law, despite the fact that the state of emergency legislation under which they appear to have been acting had been declared unlawful. So we're saying a couple of things to the court. The authorities didn't obey the law that was imposed on them. They didn't obey the procedural provisions that they had to follow in order to carry out an eviction such as this one. Our applicants, and in this case, this is one of the applicants, is particularly vulnerable. And the case should be considered, the exhaustion of domestic remedy should be considered in light of the person's particular vulnerability. And you see that we quoted a case called MSS versus Belgian and Greece. In that case, there had been a violation of Article 13 taken in conjunction with Article 3 because of the deficiencies in the Greek authorities' examination of a person's asylum application. Because of deficiencies in the procedural process in that case, there was an Article 13 violation and no need to exhaust domestic remedies. And we're saying the same thing here. Because of systemic deficiencies in the way the authorities in Milan in particular handle these kinds of cases, and in light of their clear breach of national law, we shouldn't have to exhaust domestic remedies. If they had given us an official notice and said at the bottom of the notice, if you want to challenge this, go to this court, do this and that, we would have been required to do that. Possibly. The other argument we made was that we shouldn't have even had to do that, because we're arguing, and this is quite innovative, that expelling someone from their home is a bit like expelling someone from the territory of your country. If what they're claiming is that their eviction will result in Article 3 ill treatment, they too should have access to a remedy with automatic suspensive effect. So what we're saying is that the people in Milan, in their settlement, who are facing imminent eviction, are a bit like the person sitting in Charles de Gaulle Airport, facing imminent removal from the country. In both cases, they're claiming that there's going to be an Article 3 violation, that the eviction will be contrary to the prohibition on inhuman and degrading treatment, or in any event, that it's an Article 8 violation, the right to respect for private and family life, that is so severe that it merits this kind of remedy with automatic suspensive effect. And that's what we said there. She claims to be a violation of Article 3, and so was entitled to a remedy with automatic suspensive effect. The harm was so irreversible that she was entitled to a remedy with automatic suspensive effect, and that there's a case law from the court, Winterstein and Bruce, finding that there was a right to have the court consider the matter before the eviction took place. The 6-month rule. Applications must be introduced within 6 months of the date of the final decision. If you are not sure whether you have exhausted or not, the advice that I give, and I think most people would give, would be to submit your application. See whether you've exhausted or not. If you've not exhausted, the court will come back to you and say you haven't exhausted. If you then exhaust, you can go back to the court. Now, one thing you have to be careful of here, don't go to the court instead of pursuing a domestic remedy that you think might be effective. Do both. Because if you go to Strasbourg and they say you haven't exhausted, and then you miss the time limits to exhaust domestic remedies, you're out of luck. You can't go back to the domestic courts, and you cannot go back to Strasbourg because you violated procedural rules. In terms of the new Rule 47, which is enforced from the 1st of January, giving you the rest of the rule now, the date of introduction of the application, for the purposes of Article 35.1 of the Convention, shall be the date on which an application form satisfying the requirements of this rule is sent to the court. So we used to be able to send a letter of introduction that would stop the 6 months. Now what the court is saying is that they will consider the 6-month clock to be stopped on the day that you send a valid application, which is much stricter. If, for example, the European Court decides that we were lacking a vital signature in our application, the 5th of February, when we sent that application to the court, does not stop the 6-month rule. That may not be a problem with us. If we have otherwise exhausted domestic remedies, or were excused from exhausting domestic remedies, the 25th of November was the day the violation took place. So we're still within the 6-month time limit, if we can get hold of our clients to get them to sign the form, if that's the flaw. So that may still be okay. But it's only a valid full application form that stops the clock.
And it will be much stricter once the 4-month rule.
Well, it'll be 4 months. Yeah,
will be
exactly.
But why to sit and wait to see what
Oh yeah, well, we're trying to do that as well. In this case. No, we are. But the difficulty as well is that our clients, in this case as in many other cases, are in a particularly vulnerable position.
Well, 2 out of 3 disappeared and went back to Romania and
Cannot trace it.
So we're left just with their forms of authority. I should say we have one case, which is probably the strongest case for many reasons, where we have the signatures on the forms as well, and we're still in touch with the clients because they've remained in Italy. So that may be the case that we take forward mainly. Where it finds it justified, the court may nevertheless decide that a different date shall be considered the date of introduction. So let's say we write to the court and we say, look, we had a form of authority signed by our clients before the eviction. They got evicted. We lost touch with them for 7 months as they scrambled in order to get their lives back together. They've gotten back in touch with us now, and they've signed the form. The court can decide at its discretion that that's the date that they will consider the date to stop the 6 months running. Yeah.
But usually, how long it takes for the court to decide on admissibility?
Well,
And or to say, okay, the signature, it's without the signature we cannot.
I don't know. I think in this case we may press the court to make a decision before the 6 months stop running. So 6 months from 25 November 2013. But there's no specific time. Because there are various procedures they could use. Are they going to send this to a single judge? Could be relatively quick. But are they sending it to a single judge in a stack of files like this? Because it's Italy, and because there might be a lot of applications against Italy, or Romania, which has a lot of application? Or is it a Danish case? In which case maybe there's a lot more time to spend on the case. And how does the court organize its resources in that respect these days?
But isn't there something also that this 6 months rule doesn't apply if, like, the negative or the violation is still
Yes, we'll get to that
ongoing?
now. Continuing violations. Yes. So, some violations are of a continuing, that is an ongoing nature. So that is to say, the violation, now I don't think that would be the case with our eviction. The eviction happened. You could say that there's an ongoing violation if we're claiming the failure to rehouse our clients, for
Yes.
example. But I don't know any case law that would stand up for that particular point, but we could try it. But to give you some examples, failure to investigate a disappearance. So let's say, for example, that your family member disappears, which happens, unfortunately, frequently in many countries in Europe, and the authorities do no investigation. That's an ongoing violation, because it's if you like, every day it's renewing itself, the failure to investigate. If you've been prevented from returning to land that you own, there were cases in Azerbaijan and Armenia about this, when it was sort of a kind of ethnic cleansing thing happened, and people are now unable to get back to their homes. That's a violation that renews itself every day. So the 6 months never begin to run. That doesn't mean, however, that you can go to Strasbourg whenever you like. There is still an obligation, a duty of reasonable expedition, or a diligence, a due diligence obligation. You have to apply to the court once it becomes clear that you don't have access to an effective remedy. And the court will declare inadmissible applications where people haven't complied with that duty. So Varnava versus Turkey was about a disappearance. And in that case, the court set out pretty strict standards for this, right? They said basically, in cases of disappearances, the evidence starts to go cold pretty quickly. So you have to seize the court relatively quickly once you realize you don't have an effective remedy, because otherwise the court's judgment won't make any difference to your case. Court was a bit different in the case of the Azerbaijan case and the Armenia case. Those were the cases that I mentioned about people who can't get back access to their homes because of the way things happened in the conflict that happened there in the 1990s. In those cases, the court said, well, things don't go cold quite so quickly in a case like that, because the property is still there. The situation is still more or less preserved. So the court will be a little bit more lenient with that. And the court said that internally displaced people are particularly vulnerable. And being particularly vulnerable means that the court has to be a little bit more flexible. And we said this in our application to the European Court. The court's case law requires that the question of exhaustion of domestic remedies be considered in the light of a particularly vulnerable status. And we quoted MSS for that, but the Azerbaijan case and the Armenian case are equally as effective for that.
I think non-execution of judgments is also
Yeah, another indication of, yeah.
continuing violation.
What about?
Oh yes, you're quite right. Yeah, the non-execution of a judgment would be. Yeah.
What about if the European Court of Justice, Court of Justice, EU said
How would that interact? Well, look, there's one case from the European Court of Human Rights, I mentioned it already, but in a different context, that says that European Commission infringement proceedings are not an effective remedy. So I don't think European Commission
But
infringement...
would it be like a proof that, like, make your case stronger?
Yeah, I suppose it could, if used in the right way. It would certainly, if there are successful infringement proceedings under EU law, for example, for discrimination, that would certainly strengthen your case on the merits, wouldn't it? That there's a violation of the European Convention on Human Rights. How it would interact with the procedural requirements of the convention, I'm not sure, to be honest. I don't think the fact that there's been a set of infringement proceedings can give new life to you if you've not exhausted domestic remedies. I don't think so, but that's an interesting point.
But maybe if in the EU, because EU should accede
To the European Convention,
then
yeah.
maybe it could change the whole.
Exactly, and particularly if you're bringing, eventually the European Union will become a party to the European Convention on Human Rights. And at that point, you can bring your case against the EU. And there are huge question marks over what it means to exhaust domestic remedies in that context. One of the things that you might be able to claim, actually, is that the failure to take an infringement proceeding against the Czech Republic, for example, or Slovakia, or another country that we say is in breach of the Race Equality Directive, is in and of itself a failure of the EU's obligations under the convention to take measures appropriate to stop a violation. That's a very difficult question to answer, but it would be interesting.
So you just want to talk this non-implementation of domestic or international ones? Because you said it's continuous.
Oh, I think it would be the non-implementation of a domestic judgment.
The domestic.
The non-implementation of a Strasbourg judgment is not a matter for the European Court of Human Rights. It's a matter for the Committee of Ministers under the Convention. But for example, I mean, I'm just thinking of a case that I was involved in. I mentioned to you, I think already, the English mother and the French father and the children being kept in France illegally. Now, she took her case to the French courts to get her children back, sent back to England, and the French courts ordered them returned to England. The complaint was about the failure of the French authorities to carry out that order and actually return the kids to England. I think we probably have a continuing violation there, but the issue didn't arise because we lodged the application within 6 months of the final decision ordering the children returned to England. So we didn't test it. For good reason. You wouldn't want to have to test this.
And independent human rights mechanisms are not considered an effective remedy, or they are
Which ones? What do you mean?
equality body, ombudsman?
I think it depends. I think an equality body could be considered an effective remedy if it has the kinds of judicial powers. So for example, in some countries in Europe, if you have a discrimination claim, you can go to the equality body. The equality body can make a determination, and if you're unhappy with that determination, you can then appeal that up. I would think that that's an effective set of remedies that you can exhaust. But in some cases, an equality body doesn't have the same kinds of powers to deal with complaints. Now, sometimes people will try to reignite, give themselves a new life in this by exhausting a new set of remedies. But if the remedies that you're exhausting are not effective, it's not going to help you. So some people will say, okay, I'm well outside the 6 months now, but I'm going to go to the ombudsperson's office to try to get this resolved. And then when you lose with it, and the ombudsperson says, I'm not dealing with this, you go to Strasbourg and say, look, I exhausted. But no, if it wasn't effective to begin with, you can't. It doesn't help. Cases being considered by another international body. What are the international bodies that we're talking about? Bodies that count, so that you cannot lodge your application with them and lodge your application in Strasbourg. The UN Human Rights Committee. Other UN bodies that accept individual petitions. The International Labour Organization. Bodies that don't count, just some examples. These are not exhaustive, I should say. The UN bodies that don't receive individual petitions and petitions. One example is the UN Committee for Missing Persons in Cyprus. NGOs don't count. Someone can't exhaust remedies, especially by coming to us, but to certain other bodies. The European Commission and its infringement proceedings, which I just mentioned. In relation to the European Commission, for example, this woman, Ms. Carusiotis, the German citizen whose child had been taken by the father to Portugal, she did two things. She lodged a complaint with the European Court of Human Rights, and she lodged a complaint with the European Commission, saying Portugal is in violation of EU Regulation 2201 of 2003 on dealing with these kinds of proceedings. And the Commission opened a dossier on this and looked into it. And the Portuguese government has said, whoa, we're being investigated by the European Commission, an international body. She can't do both. And the European Court said no, because the European Commission is only competent to bring infringement proceedings, which looks at the Portuguese system as a whole, not any one individual case. So that's why, for example, it would be interesting to see how they deal with collective complaints under the Economic, Social, and Cultural Rights Committee. Yeah.
When we are referring to cases being considered by another international body, are we referring to the merits under, or just the case per se?
It has to be, that's an interesting question as well. It has to be the same case and substance. So for example, yeah, let's say that we have imagine that we have a group of women who have been subject to forced sterilization.
Yeah.
Some of them decide to go to the European Court of Human Rights. Some of them, on virtually the same facts, decide to go to CEDAW. I don't think that's a reason for declaring this group's, the ones who have gone to the European Court of Human Rights, inadmissible. Just because they could have gone to CEDAW and didn't, and just because there are similar cases pending in CEDAW, doesn't mean that their applications are inadmissible.
Okay.
That's my understanding. Yeah. However, if all of them went to CEDAW, and then some of them said, oh, I'm also going to go off to Strasbourg, that's why they would be ruled inadmissible.
But yes, but if you claim violations of different rights,
I don't know the answer to that, actually. I suspect it's the same standard as it is for exhaustion of domestic remedies. Have you made the same claim in substance? So if you go to the CEDAW committee to say that it was inhuman and degrading treatment, and if you go to Strasbourg to say it violated my right to respect for family, I don't know the answer to that. You want to try different articles in different places. I don't know the answer. I'm sure there's an answer out there in the case law of the court, and I just haven't seen it yet. My suspicion is that it's the same standard, though, which is are you raising the same complaint in substance? And my suspicion, again, I'm familiar with the Carusiotis case. Obviously, she didn't claim a violation of Article 8. I don't think she would have claimed a violation of Article 8 of the European Convention when complaining to the Commission. She would have claimed a breach of EU law.
Yeah.
But it would have been the same in substance. But I'll take a look at that. I'll make a note of it. Significant disadvantage, again, I don't think this is going to cause us much of a problem, but this was added by Protocol 14 of the Convention, and it's a de minimis notion. Basically, your complaint has to be about something that is significant enough to merit the use of the court procedure. And so to give you some examples, lots of people are victims of unfair trials around Europe. Sometimes those unfair trials are about small amounts of money, right? In several cases, the court seems to find that anything less than 200 euros in your case is not likely to be a significant enough disadvantage that your case should be considered by the European Court of Human Rights. Let's say that Andrea and I have a dispute, and she thinks that I owe her money. And we take our case to the Hungarian courts, and the Hungarian courts give her a grossly unfair trial, right? They're sexist towards her, and they say racist things about her from being from Serbia, and that sort of thing. And it's obvious that there's been a huge problem here. But the core of the case is about the 200 euros. Or 100 euros. If she's going to get her case past this admissibility criterion in Strasbourg, she's going to have to show that there's other disadvantages involved as well. Now maybe the fact that they've been racist and sexist towards her would then bring her over the threshold. So that's how she could get her case in. But if she only has the 100 euros to hang her hat on, they're going to dismiss the case. To give you some other examples, in the Czech Republic, like in many countries, you have a system in the courts where when you go to the highest court, there is an officer of that court, a kind of advocate general, who gives an opinion that the judges of the court then rely on, normally, when making their judgment. And what's supposed to happen under Czech procedure in the highest courts is that everyone makes their submissions, this advocate general type person gives an opinion that the court is going to rely on, and that opinion is supposed to be given to the parties who have an opportunity to comment on it. And for some reason, I guess for administrative purposes, they seem to have forgotten in several cases to send that opinion to the parties to give them a chance to comment on it before the final judgment is delivered. So people went to the European Court of Human Rights saying, I've been deprived of my right to a fair trial. I have a right to comment on that opinion before the judgment is taken. Now normally the European Court of Human Rights before Protocol 14 would have said, quite, yes, you've been deprived of a fair trial under Article 6. But now the court will examine those cases to see, did being deprived of that opportunity to comment on this opinion really result in a significant disadvantage? And in several cases the court has said, no, your case was pretty obvious. There was nothing that the Advocate General said that was particularly likely to sway the court in any direction, no significant disadvantage, and they dismissed the cases as inadmissible. This is the thing that we talked about before. Article 34, individual applications. The court may receive applications from any person, NGO, or group claiming to be the victim of a violation of the high contracting parties. And you see I've added in some funny clip art there about group, because I don't know yet how we make a group application. It's something that I have struggled with. I mentioned this case to you about 350 Ethiopians in Norway. We could have had that situation in the Italian case. As it turned out, we don't have 700 clients, but I'm not sure what we will do when we do have 700 clients. But there it is, group. Just to say about NGOs, the ERRC can only make a complaint as the ERRC if we have been the victims of a violation of the convention,
Not for someone else.
not for our clients. And if we say that, we can even say, oh, we're very interested in ensuring that Roma are not subject to discrimination or to these kinds of violations, that's not enough to make us a victim. We could have a situation, which like the situations that are happening in Russia now with some NGOs, where their freedom of association is being violated. That might be Memorial, for example, might eventually have a case in the European Court of Human Rights. Yeah.
They do already.
Oh, they do? Okay.
What
Because
if-
it's law.
Yeah.
What if from domestic level we are pursuing public action?
Ah, that is the question. It's a very interesting question. And I know, for example, that our good friend and colleague Lila Farkas is looking into this. So what happens if it's ERRC pursuing the case because the domestic legislation allows us to bring an actio popularis? My immediate off-the-bat answer would be, no, I don't think we're likely to be allowed to go to Strasbourg, because the characterization of the parties in domestic law doesn't make you a victim in Strasbourg automatically. Well, let's say, I'm thinking we have a case in Slovakia, for example, where there was an eviction. The clients don't want to take the case forward, but we have the possibility under the Slovak procedure to take the case ourselves as the ERRC. If we then lose the case and want to go to Strasbourg on the Article 8 issues about the housing, or even Article 3 issues, I don't think we would have standing in Strasbourg. But let's say we were deprived of a fair trial while we were taking the case forward, that there were flaws in the process so significant that we were deprived of that opportunity that we normally have under domestic law to bring the case. Then we could go under Article 6 to the European Court of Human Rights. Let's say, for example, that the ERRC is trying to get information under freedom of information laws, and that we're refused that information in a way that's incompatible with domestic law. We have a right as an organization under Article 10 of the European Convention on Human Rights to receive information. We could bring that case to the European Court of Human Rights. And I know that some other people are trying to think about this creatively and trying to get more cases brought by NGOs to the European Court of Human Rights. So it's an interesting area. That's probably the most I can say about it.
And here about the group, I would be interested if you want to take an application as a group, then the whole group had to exhaust all remedies.
I don't think
If you
that
have 700
it would
people.
depend. If you have people who are all in exactly the same situation, and one person has exhausted, and the case law at national level is such that it's clear that everyone in the group will lose, then I think everyone can go straight to Strasbourg. And I give you a very good example. Well, a very good example. It's a bit maybe exceptional, but in the UK, for example, prisoners are not allowed to vote. If you are in prison on election day, you cannot vote. The reason why I say exceptional, there's actually a case law from the European Court of Human Rights on this. But it's now obvious that there's a violation there. When the next time, there'll be an election actually, there are European Parliament elections coming up. If I was a prisoner in the UK on that day, and I had the right to vote in those elections, I would make an application to Strasbourg immediately. I'd make it now. I'm going to be deprived of my right to vote this May.